I'm sorry, did Miss David, did you introduce yourself?
Oh, you're muted.
I'm sorry. Still having difficulties 10 months later. Megan,
I know.
last week out of nowhere, I couldn't get the video to work. So go figure. Megan David, guardian ad litem. That's better.
All right, let's proceed.
Plaintiff calls Delicia Gayton.
Ms. Gayton, please raise your right hand. You need to unmute, ma'am.
No, you're still muted.
There you go.
Can you hear me now?
Yes. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, let's proceed.
Good morning, Ms. Gayton. Will you please state your full name for the record?
Delicia Celeste Gayton,
And where do you currently reside?
Dallas, Texas.
What's your current address?
It is 2007 Nantucket Village Drive, Dallas, Texas, 75217.
And are you the mother of Delilah Gonzalez?
Yes.
Do you have custody of Delilah?
Yes.
Did you have custody at the time of the wreck on April the 27th of 2019?
Yes.
And Delilah is a minor, correct?
Yes.
And at the time of the wreck, I show that Delilah was 10 years old, right?
Yes.
And you understand that we're here in court today as a result of a car crash that occurred on April the 27th of 2019, right?
Yes.
And Delilah was treated for injuries to her right hand, arm, neck, and back, correct?
Yes.
And she incurred about $6,990.76 in medical bills.
Yes.
Did Delilah recover fully from her injuries from this wreck?
Yes.
And you've agreed to settle Delilah's case for $14,000. Is that in Delilah's best interest?
Yes.
And out of the settlement for $14,000, there are attorney's fees of $4,666.68, correct?
Yes.
Case expenses of $261.32.
Yes.
And Delilah's portion is $5,578.75 to be put into the registry of this court.
Yes.
And have you had an opportunity to review these settlement disbursements?
Yes.
And have you had an opportunity to have all of your questions answered regarding the settlement disbursements?
Yes.
And again, do you agree that the settlement for $14,000 is in Delilah's best interest?
Yes.
Do you agree with the amounts that are to be paid and to whom they are to be paid?
Yes.
Are you happy with the representation that Delilah receives from our firm?
Yes.
And you understand that $5,578.75 is going into the court's registry for Delilah.
Yes.
And you understand that neither you nor anyone else can get the money that's in the court's registry until Delilah turns 18.
Yes.
And you understand that the money will be paid to Delilah solely for her use and benefit.
Yes.
And you understand that by entering into the settlement agreement, you're waiving her rights to a jury trial.
Yes.
And you understand that a jury in Dallas County may have awarded her more money, may have awarded her less, may have awarded her the same amount.
Yes.
And are you asking the court to approve this settlement?
Yes.
Thank you. Pass the witness.
Jones?
Good morning, ma'am. I do have a few questions for you. Do you understand that if your daughter requires additional medical care in the future, before she turns the age 18, that you would be responsible for paying for that care?
Yes.
No further questions, Your Honor.
David?
Yes, for the record, this is Megan David, guardian ad litem. Ms. Gayton, how are you doing this morning?
Good, thank you.
We met and chatted, well, virtually met and chatted over the phone, that's right?
Yes.
And pretty much the other attorneys have covered everything that we need to put on the record. But I just want to make sure you understand that the amount of $5,578.75 will be placed into the Dallas County Court Registry for Delilah's use when she turns 18.
Yes.
And you have expressed to me that while she was injured and she did receive medical treatment for her injuries, she has recovered and she is doing okay.
Yes.
That's good to hear. And she'll be, looks like she'll be 12 next month.
Yes.
Preteen girl. Okay, I pass the witness. I believe that's all I have.
First off, ma'am, do you have any questions for me? I'm Judge Hoffman.
No, I don't. Thank you.
Could you just describe in a little more detail, what were the injuries to your daughter?
It was like her fingernails were ripped off, her arm and her shoulder and her back was pretty, banged up.
And how is she doing now? Did her fingernails grow back?
Yes, they did. She's doing much better. She's actually, she plays volleyball, so she's excited. She's able to, move forward on her activities.
And her back and her arm are doing better, or
Yes. Yes, she did her full recovery as far as the treatment. So she's doing much better.
And you don't think she needs any she hasn't been told by any doctor she needs any future medical care?
No, she doesn't.
All right. And you're recommending the settlement be approved?
Yes.
Oh, sorry.
All right, Ms. David, why don't you give your report?
Sorry, Judge. Sure. So this was a car accident back on April the 27th of 2019, so about a year and a half ago now. Delilah, the minor, was a passenger in a vehicle driven by her grandmother. Defendant seems to have ran a stop sign, T-boned their vehicle. Delilah was taken from the scene to Baylor, where she was treated for cuts and bruises. As Ms. Gayton said, her fingernails were damaged and ripped off because of her gripping something to brace for the impact. Luckily, her nails grew back and there was no lasting effects from that. After she was treated at Baylor, Ms. Gayton took her daughter to see her pediatrician, where she was checked out, and the pediatrician recommended some future care because of muscle spasms and sprains and strains, neck, back, and her hand or her arm. She did complete a 2-month chiropractic plan at Mesquite Injury Rehab. And I guess because she's so young, she seems to have recovered quickly and fully. So we're glad to hear that. She was released from care and hasn't had any treatment since it looks like June 2019. So I think she's doing well, and I am asking the court to approve the settlement. Okay.
And I understand that there's been an agreement as to the amount of the guardian ad litem fees. Is that correct?
Yes, Judge. I think it is $1,250, and I only noticed after I filed my guardian ad litem report that amount is incorrect. I put $1,500. I think I was getting 2 prove-ups mixed up. So the amount is $1,250 as stated in the final judgment.
That's grade 2, Ms. Eldridge and Ms. Jones.
Yes, Your Honor.
I guess really Ms. Jones, is that a grade 2?
Yes, Your Honor. The defendant is covering the cost of the guardian ad litem.
Perfect. We had a prove-up this morning where there was not an agreement, and we had quite a discussion about that. Ms. David's fees on this were extremely reasonable. So anyway, the court will approve the settlement as requested by the guardian ad litem. Ms. Gayton, I wish you the very best of luck, and I hope your daughter continues to recover. And did you anything else we need to chat about? I've signed the agreed judgment. You should be able to get it offline by tomorrow.
Perfect. The only other thing, Judge, I have the form to submit to the court registry. I have everything filled out, and I'll just confirm all the information with Ms. Gayton, and then I'll send that over to Ms. Jones so they can send that in with the check to the registry.
Okay, great. Do you want me to put you in a breakout room to do that, or what did you, or were you going to just call?
Well, I really only need one piece of information. Yeah, if you want to do that, that would be fine.
Okay.
Or I can just call Ms. Gayton, whatever's easiest.
Doesn't matter. I'll put you in a breakout room so that's easier. And if you guys are welcome to leave directly from there, so you don't need to come back. All right, thank you, for your service, Miss David, and
Thank
you guys
you.
have a great day and be safe. Okay.
Thank you, guys. Thanks,
you.
Judge.
Judge.
All right. Ms. Masterson and Ms. Voltmer, are you here for the motion to compel?
Yes, we are.
All right, Ms.
Yes, we are. Morning, Judge.
How are
Two
you
motions to
guys?
compel. Good. How are you doing today?
Good, good. I read y'all's motion to compel, and it looks pretty contentious, so that'll be fun. Well, have you had a chance to confer on each of these different requests?
We have, Your Honor.
Okay. Let me do this. All right, I just want to let you know we're on YouTube right now. We're going to go on the record on cause number DC 1918934, Linda Payne Scown versus Baylor Scott and White Health. Counsel, make your appearances.
It's Bess Masterson. I'm counsel for the plaintiff, Linda Payne Scown.
Alicia Voltmer, counsel for defendant, Baylor Scott and White Health.
Okay, is there two motions to compel still said? Is that right?
Yes,
Yes,
Judge.
Your Honor.
Which one was filed first?
Mine. Defendants.
Why don't you go first?
All right, Your Honor, this is an age discrimination case where the plaintiff claims that because she was fired over the age of 40, that she must have been discriminated against based on her age. We have deposed the plaintiff, and she testified that she seeks both compensatory and non-compensatory damages in this case. In her deposition, and we have included that testimony with our motion to compel, she made a number of statements about what it is she's actually seeking. And for example, she says that she seeks lost income because she was the family breadwinner. She seeks damages for inconvenience, had to go into her savings to make ends meet, had to borrow money from credit cards to make ends meet, has to support two households because she says she has to work in Colorado and pay taxes in that state. She says she had to borrow from credit cards, and she says she had to borrow from her 401k. So based on her specific testimony about her damages, we sent requests for production on each of those.
Are any of those things recoverable? I mean, I know she can do, front pay, back pay, sometimes lost wages. I don't remember for age discrimination. I haven't had a whole lot of those. But a lot of the things she has testified about are not going to be something that's recoverable at trial, right?
Well, if the plaintiff stipulates that they're not going to seek recovery, then we wouldn't have an issue. But right now, compensatory and non-compensatory damages are recoverable under the Texas Commission on Human Rights Act. And I haven't seen any case law that limits that to just front pay and back pay.
Oh, I know it's not just front pay and back pay, but the things that she's requesting aren't going to be. I've never seen a case where they were recoverable, but Ms. Masterson, what is your position?
Well, Your Honor, she's just asking for what's recoverable, which is front pay, back pay, interest, attorney's fees, her expenses in moving to Colorado to get a job, and we did already produce that. We're not asking for these things, and what she's requesting is highly harassing and invasive, copies of all bank and credit card statements for the past 3 years. So we have produced everything that we're relying on for damages, Your Honor.
Okay.
Well,
Does that address your issue?
She is, Your Honor, she is asking for inconvenience damages. And if she's going to get up on the stand and testify about all these things about credit cards and 401ks and having to take money out of her retirement and, you know, pay more taxes, those are things that we're entitled to go into if she's going to testify about those things to support an inconvenience request for damages.
Is she going to testify about those things, Ms. Masterson?
Well, if a question's asked, I guess she'll answer it. We're not intending to put evidence of that in. We'll just submit the normal damages.
Well, I'm not sure that that actually responds to everything that we've asked for. She says she's supporting 2 households now living in Colorado. I think we got 1 invoice for moving expenses. So for example, if she's saying that her apartment costs more or she has to buy groceries in Colorado, anything like that, that is a hard damage that we're entitled to see if she's got evidence of.
We have already produced what she has evidence of in writing from her Colorado expenses.
Okay, that I think it was 1 or 2 pages of documents. If, again, Your Honor, if they're going to stipulate that that's all they're going to ask for if this case goes to trial, that's fine. But what we don't want to see.
I think that's fair. I mean, if you seem to be kind of equivocating here. So if you are going to take the position that you're going to be able to recover this damages, for example, for maintaining 2 households, and she should probably get that. I don't think you can recover that. At least I've never seen it.
Well, we really just intend to put on evidence of her lost wages and what you're normally entitled to. So we have already produced documents pertaining to all the damages we intend to request.
So how about we do this? I'm going to order you for each of these different questions about the damages, either to respond to them or make a stipulation that you're not seeking them.
Okay, Your Honor.
So either say in there, the plaintiff is not seeking the cost of maintaining 2 households. I don't remember all the different things, but or you need to answer the question, because it's only fair if you're going to try to seek them that you provide discovery on them.
All right, Your Honor.
All right, does that address all of the defendant's issues?
Except for the inconvenience part, inconvenience is a recoverable damage. And again, we just want to make sure that we're not going to get something shoehorned under that we've asked for that we're not going to get today. So if the plaintiff were to testify on the stand that she was inconvenienced and then starts talking about the 401k or
you need to quantify the inconvenience damages. So what exactly you're seeking for that?
All right, Your Honor.
Anything else?
No, Your Honor, that addresses everything. Thank you.
Go ahead and prepare an order on that. Let's go to the next motion to compel.
Yes, Your Honor. There's really just 2 categories of things that we're requesting. The first thing is request for protection 12, 13, and 15, which basically are asking for emails between plaintiff and her supervisors or among her supervisors about her. All we've gotten are just 3 or 4 emails that talk about things right before she was terminated that she sent to them. And so we think we're entitled, since they're claiming that they fired her due to performance, entitled to get the emails so that we can show that she was actually turning in a good performance and doing a good job. We're willing to limit it to 5 years, and we had talked about that before we filed the motion to compel. I believe that's one of their main objections, is because she worked there for over 20 years. So we're willing to limit it to that and to issues pertaining to her performance, but they still would not produce it. So that's why we're here.
Response.
So the actual initial request says any documents, and by the way, these are between supervisors and higher up level people from the plaintiff and between plaintiff and supervisors. What they asked for was 20 years of documents of any emails between these people. And Your Honor, I think you are well versed in Lofton versus Martin, Dallas Court of Appeals, Texas Supreme Court says You cannot ask for all emails between two parties. You've got to give some kind of boundary on that. What do you want? What are you looking for? That's a classic phishing.
But hasn't she done that?
Well, no, Your Honor. What she initially asked was not for anything regarding performance. She had other categories that she asked when we conferred, which we didn't agree on. With respect to performance issues, in a 5-year period, what is that? If the plaintiff emails her boss and says, I'm submitting this report to you, is that about her performance? I mean, I'm not sure what she's asking.
How would you suggest to clarify to make it more clear?
I don't know, but what we have produced is not just, and she has said we've only produced emails of performance between them, or excuse me, what was it? She said something about we only produced a handful of emails. That's not true. We produced a lot of emails between other people, among other people, about her performance, and specifically about complaints about her performance. The people that she's asking about testified, and we've attached that information too. They've testified that most of their discussions were verbal. And when they weren't verbal, we've produced those emails. So I'm not sure when you say about her performance, what exactly is that they're claiming that they want that we haven't produced?
Ms. Masterson?
Well, as I said, we've only gotten very, very few emails. And so we would like to see more emails. It's just really a handful regarding right before she was fired, an issue with a coworker, but there's nothing about her performance when she's worked there, projects she's completed, anything. And so it makes
did she have performance reviews? Have you provided those?
Your Honor, you at our last motion to compel hearing, you compelled us to produce all of her comparators files, which we produced, all of her write-ups, all of her performance reviews. We've produced all of it, absolutely all of it, hundreds and hundreds of pages of it.
And this just pertains to the emails, because we really haven't gotten many emails, and that's how they communicated while she worked there.
And they deposed my two witnesses, Your Honor, who said almost everything was verbal. We've provided that to the court. And what they didn't have that was verbal, I have produced. So when she says there's just, we want to see everything between these two people, that's a fishing expedition. I can't produce what I don't have.
I know that, but you're saying that, I mean, you're indicating to me that there's something out there. There's a lot, you're at one point, it kind of seems like you're saying there's a lot of other emails, you don't know how to narrow them down.
Sure, she worked there for 20 years. If she emailed her boss and said, I'm taking Friday off, you know, provided that hasn't been deleted pursuant to a 20-year record retention policy.
She's agreed to limit it to 5 years, so.
Okay, but
last 5 years.
Even 5 years, Your Honor. I mean, every issue about everything that she ever did with a supervisor or told a supervisor, I can't see how that's relevant, and that's fishing. You know, if she says anything, you know, I don't want to do Ms. Masterson's job for her, but if she wants to request something very specific, that's another thing. But as far as issues that her client had, I have produced those emails, and no, it's not just 1 or 2 emails that keeps being represented. That is false.
You know what? I'm not sure how to do it either. So I'm just going to order the last 5 years related to any complaints or commendations, I guess, about her performance. I know it's a little bit vague, but I don't know this case as well as you guys, and neither side has really given me any direction. So that's kind of my best shot at it.
Thank you, Your Honor. And we just had one other category that we were requesting, which is we requested all PCEs submitted from all the North risk managers for the months of November 2018 to March 2019. And this was just a recent request based on the deposition. They asked her in her deposition if her supervisor ever spoke with her about not doing enough PCEs. And she maintains that she always kept up with the PCE. So we're just asking for that.
Tell me what a PCE is again.
It's a report, and I asked her, she says there's 11 reports for the hospitals, and from Baylor University Medical Center, there's 2 reports. So it's just 13 reports to show that she was doing the PCEs for November 2018 through April 2019, just very narrow.
What is a PCE? What does that stand for?
It's just reportings. I'm not exactly sure what the acronym is. Alicia, do you know?
I do. It's, and I can explain it, Your Honor, when you give me the opportunity. It's a potentially compensable event.
It's a what?
Potentially compensable event.
What does that mean?
So the way that it works is anybody in the hospital system can enter into a computer system called MIDAS, a PCE or a potentially compensable event. So if you see a patron slip on a floor in front of you, or you find out someone has an infection, anything that could potentially bring on a legal claim against the hospital gets reported into this system. Anybody can make a report. With respect to the clinical risk managers, of which the plaintiff was one, their job was to receive reports of those events, those PCEs, review them, and determine if they needed to have a higher level of review. If they did, that information went into a separate system called STARS. So what the plaintiff's requesting, we don't even understand, because she's asking for PCE reports. Well, anybody can assert a PCE report, and then when it goes into the system, there's a completely separate team called patient safety that actually has to figure out if something is truly a PCE or not, meaning is it really a legal claim that the hospital needs to investigate further. So what the plaintiff is asking for is something that we don't understand or know how to produce, because you can't track it. There's not 13 reports. I'm not even sure where Ms. Masterson is getting that from. I have spoken to the team that handles these 2 computer systems, and anybody can enter in an event. It's not necessarily a PCE until the patient safety team says it is. So what they're asking for, it doesn't even make sense to us. All PCEs submitted from North risk managers, not sure who those folks are either. We can't track from start to finish. If the plaintiff saw an infection, let's say in a patient room, and submitted that into one system, we can't track it all the way to the final patient safety team to see, was that the plaintiff's or somebody else's? I've already checked on that, and we can't do that. The system doesn't do it.
Is there any way to search this? So you're basically wanting anything where your client was involved in a PCE, is that right?
Yes, the reporting to show that she was doing her job of managing the PCEs. And she told me that there were 11 reports for the hospitals and 2 for BUMC. So there's 13 reports, and I can get from her more information if there's a specific name of the PCE.
From the hospital report. And 2 from what? BUMC?
Right, the Baylor University Medical Center.
I know if you say BUMC that my court reporter will want me to spell it. So BUMC is okay, BUMC, okay?
Yes.
So that's not the way it works, Your Honor. I'm not sure what the plaintiff is referring to. She didn't manage the system. I am not aware of 13 reports to show, quote, she was doing her job. What the hospital looks at, and by the way, Baylor University Medical Center is the largest facility. So to the extent, and I'm just going to divert here for a moment, to the extent the plaintiff says she wants to see the same reports for other hospitals, you're comparing apples and oranges. You might have a 100-person bed hospital being compared to a 900-person bed, which doesn't make any sense, because the potentially compensable events that end up at the very end of that process are going to be more when you have more patients. But as far as this contention that the plaintiff says there are 13 reports that she was, quote, doing her job, there aren't reports like that we can run. Like I said, I've talked to the client.
Okay, so let me make sure I kind of understand how this works. So there's these reports, and the plaintiff was in charge in receiving the reports, is that right?
There are something called work reports, and then I can't remember the name of the other one, but there were two types of reports that get generated daily that all of the clinical risk managers would review. And their job was to look and see if any of those things, the patient fall, the infection, whatever it may be, could be a potential claim for the hospital. If they saw those in MIDAS, the computer system that the plaintiff is asking about, that information would get transferred to a separate computer system called STARS. So the STARS computer system would then be looked at by the patient safety team that would determine if something truly was a potentially
Where does the
compensable
plaintiff fit in
event.
on this? She fits on the front end.
She fits in on looking at every event and deciding, is it something that I need to elevate up to the patient safety team so they can
So
determine
she's on the front
ultimately-
end.
She's on the front end, correct.
Okay, so Ms. Masterson, what exactly are you wanting then? You're wanting the kind of what comes in on the front end?
Well, I believe I guess I need to talk with my client to get more detail, but she just said that there's 13 reports that show the risk managers are addressing the PCEs. And that's what we want to show, because they had mentioned something in her deposition about her not doing enough PCEs. And so we're looking for the information to rebut that claim, to show that she was addressing.
Is that one of the claims in this case, Ms. Faulkner?
Well, it's one of the areas that she was deficient in her performance, but Ms. Masterson's colleague deposed 2 of my clients and asked nothing about how this process works. And in fact, they had a 3rd deposition scheduled that they voluntarily canceled. And had they asked any of these witnesses how this works, they could have gotten this explanation directly from them, but they chose not to. There aren't 13 reports that show she was doing her job. I'm not even sure what that means.
These reports, do they contain confidential information about client or about patients and things like that?
When you say reports, Your Honor, the work reports, the 2 that get spit out, that the plaintiff and the other people in her position reviewed, yes. So, patient Susie Smith, Social Security number, or ID number XYZ PDQ, had this event happen. Yes, highly confidential, HIPAA protected information.
We
And
do have a confident.
Right, but to produce all of that information, it's still not going to tell her what events eventually were considered by the patient safety team to be a PCE.
I don't think that's the issue in this case. The issue, as I understand what's happening, is your client has taken the position that she didn't properly process, I guess, these PCEs. And she's saying, look, yes, I did. And this is proof that I did. She should be able to do discovery on that if that's one of the claims in the case.
Your Honor, what they could have asked in an interrogatory but chose not to was, what's the count between Bumsy when she was there and before she was there and after she left? Because that's information that I believe we could provide.
What's the count on Bumsy?
Right, she worked at Baylor University Medical Center. She worked just in that one facility, the biggest facility that Baylor has. So 850, 900 patient beds. So if she's reporting, 30 potential PCEs a month, and we're comparing that to a hospital in, I don't know, in Plano that's got 100 beds, and they're reporting 70 a month. That's something I can compare. I can show you that there's something wrong here because we've got a 900 bed patient facility reporting very few and a little facility reporting a lot. That's information I could provide.
How does that sound, Ms. Masterson?
Yes, I believe that's what we're requesting, the monthly reports for that time period.
They're not monthly reports though. It's numbers that we can count, but I'm not aware that I can spit out a document that just says that. I think someone can look in the system and count, but that's an interrogatory. That's not a request for production. They didn't ask that.
You can't print out. Yeah.
I don't believe there's a printout for that, Your Honor. I think it's something that can be counted.
There's a variety of ways. I mean, again, this is a little confusing, but there seems to be a variety of ways we can skin the cat, so to speak. And so we could just order every single PCE she ever worked on during the 5-year period to be produced. That does seem to be could be very voluminous and it'd take a long time to redact. if your argument is going to be, like you said, that if Bumsey only did 30 and this other hospital that's comparable did 70, and somehow that's inconsistent, then we need to be able to see what the underlying data is. Why is it only 30? How did they count the 30 versus how did they count the 70? If you can, I guess my gut is that if Ms. Masterson is trying to come up with something that's easier for you to produce, then you can't kind of use it as a sword and a shield. You know what I mean? Like if you're saying, look, this would be really hard to produce, you could have just done it this other way. I mean, I don't think it's not discoverable just because it might be kind of difficult. And if it is an element of your defense, I think they need to go into discovery. And so I'm willing to listen to a proposal by you, Ms. Voltner. Is it Voltmer or Voltner?
Mer, M-E-R.
Voltmer, Ms. Voltmer, on how to make this, to provide the data that Ms. Masterson needs without having you to provide every one of these reports that she ever worked on.
Your Honor, I don't know. I'm not sure why I'm doing Miss Masterson's work for her. Her client worked in this
Okay,
area.
all right. I'm really trying to be fair to you here, and I guess I've said there's an easy way and a hard way to do it. I'll make you do the hard way. I'm trying to give you an option to do the easy way.
Your Honor, I'm trying to help here, but I'm not sure. I mean, she wants to see the numbers of the initial PCEs for every risk manager in the North, which I still don't know what those people are or who they are. She wants to see a number of everything that she input for 5 years. Is that what she's asking? I'm not even sure what she wants at this point. She didn't say 5 years, she said 5 months.
Well, I thought she said 5 years.
She said 5 months. Her response says 5 months.
Okay, 5 months.
Right, Your Honor. Well, they told her she was not doing enough PCEs, so we would like the PCEs that she processed versus the PCEs that her comparators processed, and that's what we asked for. Just the 11 reports for the hospitals and 2 for the Baylor Medical Center from November 2018 through April 2019 to show that she was processing them and doing a good job.
What reports, Ms. Masterson? What are the names of these 13 reports? Because I'm not aware of 13 reports. Can you provide me with those names? If you claim that they exist?
I can ask my client. She doesn't have any documents like that.
Why don't we do this? It seems like we're kind of going around in circles. Ms. Masterson, why don't you and Ms. Voltmer get on the phone with your client, because your client seems to know there seems to be a bit of a disconnect on exactly what's being requested. If you guys can work it out, great. Just submit an order for me. If you can't work it out, then come back to the Zoom call at 1:30. How does that sound?
Yes, Your Honor.
Your Honor, that sounds fine. I will say this, that because of the increase in COVID, it is difficult to get a hold of my client reps. Can we move that to maybe tomorrow, just in case? Because I
am starting the very first remote, I hope, the very first remote jury trial in Dallas County history tomorrow. So I am going to be a little bit busy, so I will not have time tomorrow. But I have faith in you, and I don't know that you really need to talk to your client. I think she needs to talk to hers. And if you come back at 1:30 and you're still working on it, we can always reschedule to another time. But let's see how far we can get it by 1:30.
Okay, that works. Thank you, Your Honor.
Thank you, Your Honor.
Right, guys.
Okay.
You have a great day.
You
You
too.
too.
Okay. So Tony, we'll see you at 1:30. Rhonda, we'll see you at 1:30. Andrea, we'll see you at 1:30. And did you have any questions?
No. I mean, I was kind of confused what was going on between the two attorneys. It kind of sounded similar to another case that we had tried. I can't remember the specific case, but One of them was very adamantly saying like, well, we don't know. We want the option to, I guess, file it later. It was just very confusing. I was just very confused about what.
I have to admit, I was a little confused too, exactly what it, by the end, I kind of figured it out, but what they're trying to figure out is, I guess she's in charge of kind of processing these PCEs and reporting them. And they said that she wasn't reporting as many as she should be. And so if that's part of your defense in a case, then you need to produce that information that backs up your claim. You know what I mean? Like if you were in charge of selling Hondas and they said you weren't selling enough Hondas, and then they fire you and you say, no, you fired me because you were discriminating against me. And they're saying, no, you didn't sell enough Hondas. Then you'd be able to ask, okay, how many Hondas did you sell versus other people in the same position to see if it really was. Does that kind of make sense? So they're trying to figure out what the comparators are to see if this was just a pretext, you weren't handling a PC, or was it really age discrimination?
Okay, yes, that makes sense, yeah. Because they kept on talking in circles. So I was like, what
I agree.
are they asking for?
Yeah, no, I agree with you. I totally agree with you. All right, great. Well, I will see you at 1:30.